So welcome, everybody. I'm Laurence Lieberman. I am a partner in the global disputes practice at Pillsbury. I focus on technology-related disputes, and in more recent years, I have been acting for a lot of fintech and crypto companies in their international litigation and arbitration. Today, we're going to be exploring one of the most exciting and challenging frontiers, the intersection of crypto and AI. As Rob said, you can't have a conference without somebody talking about AI. We'll move from the cutting edge of innovation, autonomous agents transacting and managing systems, through the paradoxes of trust, responsibility, and regulation, and finally to how the courts and lawmakers are grappling with these fast-paced developments. Along the way, we will be asking who can be trusted, who can be liable, and who or what is really in charge when the machines begin to act for themselves. Before we start, I'm going to introduce the panel. So at the end of the panel, Cristoph Kletzer. Cristoph is Professor of Law and Philosophy at King's College in London, Global Professor of Law at Notre Dame Law School, and a seasoned VC investor and blockchain and crypto veteran. He studied law and philosophy at Vienna and Cambridge and has held positions at the universities of Cambridge and Durham. His research focuses on legal philosophy and finance law, and he's currently the Vice Dean for International at the Dixon Poon School of Law at King's College London. Cristoph is a member of the advisory board of the Austrian Digital Asset Association, is a member of the advisory board of fintech companies, has taught and advised senior legal counsel at BNP Paribas on distributed ledger technology, and has been a member of advisory roundtables at the Bank of England on the future of decentralized finance. Cristoph has published extensively on legal, moral, and political philosophy, and on the theoretical foundations of DeFi. Next to Cristoph in the middle, Sam Davies is a managing director at FTI Consulting, where he leads the blockchain engineering capability. He's designed, developed, and implemented over 30 blockchain and AI-enabled platforms and products for clients globally across multiple industries. Sam's an expert in blockchain, Web3, and AI, with experience in architecting enterprise-grade systems, combining distributed ledgers, advanced analytics, and machine learning. Over his 19-year career as a research engineer, an architect, consultant, and engineering lead, he's worked at the forefront of emerging technologies like AI/ML, the Internet of Things, and blockchain. He's built innovative blockchain platforms and AI-driven systems for clients like Toyota, Microsoft, and the Commonwealth Bank of Australia. Sam has published papers and patents in blockchain, AI, and emerging technologies, solidifying his role as a leader, bridging these disciplines for enterprise adoption. And then, last but by no means least, Daniel Khoo is a commercial barrister at Four Pump Court with specialisms in crypto, fintech, and technology claims. He's one of a handful of barristers ranked by the legal directories for crypto asset and blockchain disputes. Daniel acted in one of the first crypto freezing injunctions before the English courts, Toma and Murray, in 2020, and he was instructed for Roger Ver in his successful defense of the high-profile proceedings in the Tulip trading case. He's regularly instructed in crypto asset disputes, both in litigation and arbitration, and we've worked together on some of those. So although it sounds like a bad joke, a philosopher, an engineer, and a barrister walk into a bar, I think it's going to be a very broad and thought-provoking session. I hope you think so too. So the way I'm going to do it, I'm going to have a sort of series of topics which each of the panelists is interested in talking about, and then there'll be some follow-up questions for the other panelists to draw out some more of the themes and explore some side paths. I'm going to start with Sam. If that's okay. And the first topic, the first question that I wanted to put to you, Sam, is all about agents and transactions. So we're seeing early signs of AI agents using crypto to buy and sell and even invest. What are the most promising real-world use cases, and how do we manage the risks of giving the machines financial autonomy?
I think, as you said, we're very much at the early stages of this at the moment. The speed with which AI has evolved and become mainstream has taken us all by surprise, even though those of us sort of working and researching in this industry. I remember probably about 7 or 8 years ago, doing a huge amount of research in something called affective computing, which is trying to get computers to understand the emotional component of speech, of language, of text, etc. And we were relatively sure this was a career's worth of research. 2019, Google released a really interesting paper. We've now got LLMs, we've got ChatGPT, which can do all of that in the space of about 4 or 5 years. And so the speed with which this has become a commodity and an incredibly easy-to-use technology, I think, has taken a lot of us by surprise. And I think that leads on to what we're seeing in the intersection with crypto. We're seeing the easy, early stuff at this stage. There's a bunch of bots which do autonomous trading, which plug into DeFi protocols and try and make things a bit faster. They can analyze more data. They can understand things on a larger scale than humans can. But it's still relatively the same thing. It's looking at how to make more money from DeFi protocols than other people. There are some interesting investment bots coming along. There's an interesting one called AI16Z, which is a DAO that uses AI to identify investment opportunities and how those can then be given an edge by the use of AI. But then it goes to a human vote. You buy these tokens, and the more tokens you have, the greater your vote power. And I think that's where we are with these use cases. It's the sort of the efficiency, the low-hanging fruit. What's really interesting to see is the number of technical platforms being developed which enable us to do these things faster and easier. There is a whole, you can just log onto any of the cloud providers, and they've got a huge number of frameworks. So something which used to take us a lot of whiteboard time with a big old rack of servers and feeling very self-important sitting there with complex equations on a whiteboard, you can now get spun up in an afternoon. And I think as we have that faster iteration of innovation, that's when we will see the kind of the real innovation happening and the new use cases. In terms of then controlling that risk, I think that that's an interesting one, and we're seeing various different levels of that risk. So the easiest and the least successful is you just tell the bot, tell the agent not to do anything bad. You try and bake into the prompt, into the instructions that it has. That doesn't work. There have been some really interesting examples when people have used these things to help them code, to help them build other SaaS software platforms or other infrastructure, and the bots deleted their database when it's been explicitly told not to. And to be fair, the bot then apologizes, but you've still lost all of your client data. The next stage that we're looking at now, and I've just been having a discussion with a colleague around this, is to basically build in kill switches. We've got bots which do stuff. And then just before they're about to execute the stuff that they do, they just have a look at a very deterministic rule set. And that deterministic rule set actually handles the transaction. Are you allowed to make this many trades a day? If yes, fantastic. If not, it's just a hard pass. You're not allowed to do that. The final area that we're seeing, which is really interesting, we've been speaking to a free trade zone around building the control and the risk mitigation in at the blockchain protocol level itself. So you have these AI agents which can do their things. You've got these rules they have to check against. But then actually built into the token technology, built into the blockchain network, the consensus protocol itself, are a set of rules which cannot be broken. You cannot transact at this rate. You cannot transact to accounts which are flagged as being uncompliant. You cannot transfer across this border on this particular set of rules. Again, we can put this very nice heuristic rule set in and ensure compliance at that fundamental level. So I think that those are sort of the 3 levels that we've got, from kind of the very easy but least efficient to we're still desperately trying to figure out how technically to build this with some of the layer 1 protocols, which will give us the most risk mitigation, the most control, but it's quite hard.
Yeah, I see that. Just to sort of explore, Cristoph, with you a little bit on this point about responsibility. Who's responsible? How are these agents responsible? How does the law sort of begin to conceptualize the concept of fault when you have the sorts of protocols and systems that Sam's been talking about?
it struggles, of course, and we know that from autonomous vehicles. We have great overlap, of course, here between self-driving cars and self-investing bots. But we have even, to some extent, greater problems with the on-chain autonomous agents. I'm going to say in what sense, and to some extent also maybe some remedies against the technological ones. So the problem is, of course, at fault is, negligence, for instance. It requires a human standard, and that doesn't apply. Usually, when we deal with self-driving cars, we deal with that with product liability or kind of strict liability. That would be an obvious, choice, and that seems to be the settled route to go down, so far at least, in self-driving cars and autonomous vehicles, to build in some kind of strict liability, product liability. But the problem, of course, the difference between on-chain bots and self-driving cars is the chain to some kind of registered entity isn't clear. You can set the agent completely free. You can have it behind, maybe an autonomous agency, a distributed autonomous agency. You can completely relinquish control of it, which nobody has tried to set, a Tesla free and say, now off you go, you do whatever you want, and you're your own person now. But with bots on chain, that could be possible. They could move around the world. When you have an accident, a car accident, it's quite clear which jurisdiction, which law applies. You have a difficulty, I'm sure you know that from your litigations in Tulip case and many others. English courts will, take jurisdiction at some point, likely, but it's not a straightforward thing. So you have kind of negligence. You have a big question mark because it's a human standard. Agent-client relation, agent-principal relationships don't seem to work because the agent doesn't have any agency in a human sense. I'm going to say a bit about that maybe later on. And the strict liability might be the only one to have kind of insurance system or something like that. So you have harder problems to solve from a legal perspective. But as we've just heard, there might be some guardrails that you might hard code onto the blockchain, into the protocol, so to speak, which is hardwired, which would keep, these bots more in line than maybe a street could. You don't want to put in concrete railings, but you can do something like concrete railings more so on the blockchain. But then again, you have the classic problem you mentioned in AI, which is the alignment problem, which these agents become sometimes very, very clever, and they just switch off certain things. We know that from many alignment cases in military, where they have a goal and then a kind of the qualification of the goal, and they just kill whatever the qualification is to turn off certain transmitters of data because they go for the effing goal. And there might be similar issues here. So I think from a legal perspective, the bots, blockchain agents pose very specific and quite big problems.
Okay. I just want to explore that. For our session today, the concept of trust is just pervasive throughout this whole discussion. I just want to explore that a little bit more on trust and reputation for these bots, calling the bots AI agents. And Sam, so if as we've said, these AI agents become economic actors, in crypto, but frankly more broadly than that, how can we build identity and reputation systems so that the people who are interacting with them, whether that's consumers or businesses, know that they are dealing with reliable counterparties?
So that's an interesting area that we've been exploring in sort of blockchain as a whole. You've got these sort of quasi-anonymous systems in some ways on blockchain. Part of our work, we do a lot of work on asset tracing, crypto asset tracing, when it's been stolen and bad things have happened. And you appear to just be following these transactions of these incomprehensible addresses. But at some point, they do have to resolve to a human or a real thing. We're not at the stage yet where you can use crypto to go to Tesco's or pay your mortgage. So you have to escape into the real world. You have to off-ramp into the real world and convert to fiat. And so we've got this kind of concept of a sort of identity being given. Wallets can have identity. When you look at some of the tracing software, they will attribute various factors to these wallets, who it is, if it's a known bad actor, for example. And we can take the exact same approach to these agents. We can then extend it further. There's a lovely standard from the W3C, who are a control internet standard, called decentralized identities. Decentralized identities, DID standard. And this is a blockchain-based kind of smart contract which gives very base proof of ownership over a thing. And that thing can be a wallet. And then you can prove ownership of that wallet that you're a human. You can attach biometrics to it. You can attach driving license information to it. You can attach KYC information to it. And the thing that decentralized identity represents can also be an AI agent. So with that identity, you've now got a grounding to prove who it is. And we're very good at proving sort of general online identity when it matters. Everyone here will log in and authenticate to their work IT system. You'll have been authenticated, you've been proven to that. I've got an FTI consulting address. I went through a bunch of stuff with them to prove it's me. I've got a whole host of 2FA and fingerprint scanning things to prove that I own that identity. When you want to go and work with a company, if you log onto a website, you know that website's true. We've got TLS certificates, we've got certificates, you've got the HTTPS bit, which proves that that domain has gone through a verification process. And we can use the exact same technology on the bot, so you know that this bot is who it says it is and has come from this specific company. You can then build these out with DIDs, with these decentralized identities. We can build on things called verifiable credentials. Now, these have been really interesting to explore from a human aspect for sharing KYC information between banks. If you've been KYC'd by one bank, you can pop it on a VC, verify a credential on your DID, and another bank can share it. So we can use the same thing for these agents, for these bots, and it doesn't necessarily have to be KYC information. It can be, as you say, reputation. eBay has a very good reputation network behind it. You can build up that trust of who you're working for. Uber has as well. You build up these network effects of who people are, and that's just from the social level. And then you can put compliance. You can put kind of the regulatory verifications. You can put any licenses you have. Again, attach them at a provable level. You've cryptographically proven that this licensing authority has licensed this bot for XYZ. You know that this bot you know who this bot is because you can prove it from that cryptographic signature. And so we can build these things up over time. And so I think that a lot of the existing technology we have in the kind of Web 2.0 world can be used in this Web 3.0 world for identity, which we can then attach to these bots as they become more prevalent.
Okay. I want to talk a bit more about this whole trust and reliance issue, because I think it's central to the discussion that we're having today. I'm going to come back to Cristoph on that shortly, but just wanted to, another one for you, Sam, sort of changing direction slightly, but also related, which is the use of AI in crypto investigations. So, AI is being used in forensic tracing and dispute resolution in crypto. Do you see AI as being sufficiently neutral to be able to perform that role, or does it bring with it, when conducting investigations, inherent bias and opacity?
So I just want to flag that we don't use AI in any of our sort of court-submitted documents. It's all human, but we are investigating how it can help. And I think what we found is perhaps AI isn't sometimes the best tool for this, and we need to rely on less imaginative technology. So AI, artificial intelligence, it can reason. If you think about agents, they plan, they reason, and they execute on a task. When we're just looking for cold, hard facts, we don't necessarily want any of that creativity. What instead we want are kind of more machine learning tools, things which are statistically provable. We know that we can tell it to do X, Y, Z, go and find this, that, and the other, and then report back on it. And it will do that. It won't have the capacity or any agency to go off and do something clever. So when we're looking at how we can use these tools in the asset tracing, it is basically just like a big data problem. We've got lots and lots of transactions that go from one place to another. Sometimes they jump across chains. Sometimes they go through tumblers, cryptographic ways to mix things up. But again, we can analyze enormous amounts of data far faster than a human can to get us that kind of base approach. And then one thing that I think will be absolutely critical in all of this is keeping that human in a loop. Once we have that data, you check it. And in some of the other investigations work that we're doing as well, sort of starting to explore how we can use technologies such as RAG, retrieval augmented generation, which is a good way of asking an agent questions about a large corpus of information. It will give you an answer, but you've no idea if that answer is true or not. So there's absolutely no way you would ever take that answer and then just include it in a piece of expert testimony. You would take that answer and then you would check it. Is that true? Is that not? And the hallucinations, the lies that these things come up with can be really convincing. And the way that they communicate with you as well, it's in such an authoritative yet friendly manner. You're going to sort of, you have that tendency to believe it. So I think, to the question, we can sort of almost engineer bias out by removing any imagination from these systems. And then as long as we make sure we've got that human in a loop, that final checking phase to make sure, is this true or is this just nonsense that sounds quite plausible, that should help mitigate any issues around that.
And there was a case in the US recently where the lawyer got sanctioned for using AI to develop a brief, and it came up with a case that didn't actually exist, and pretty embarrassing. And just to develop that a little bit, the last point, Daniel, with you, just in terms of giving thoughts on where the English courts are at the moment in terms of AI-generated evidence or findings. I mean, in crypto disputes, but frankly, just more broadly as well.
Yeah, I think you would be brave to put an LLM submission before a judge and ask them to accept it. And I would certainly have a lot of fun cross-examining an expert who had used an LLM to produce their report. That's because there's been all these publicized cases of hallucination, and lawyers have faced professional sanctions for using LLMs to do their job badly. But there is, all humans are very bad at dealing with very big data sets, whether it's big textual data sets like RAG or an LLM is dealing with, but particularly big numeric data sets. And if there is a good reason for using AI, let's say you're a financial institution or you're an exchange and you're doing KYC or fraud detection checks on your customer base, and you just cannot physically process the alphanumeric data that's being produced by all these transactions, and you use an AI tool to direct a human agent or process towards particular transactions, and that's the way that you operate, say, your fraud detection or your KYC and how to focus your efforts. If that's the evidence, it's a perfectly sensible way to do your business, and I don't think a judge is going to have any problem accepting that we all understand spreadsheets and the manipulation of large data sets, and this is just another step along the way. I think there's this, when people think of AI, they think of LLMs, but that's not the only way that it's going to change our world. And maybe years from now, we will also accept the LLM written report, but there's too much of a bad smell about that at the moment.
Okay. All right, good. Well, I want to sort of turn back a little bit to the themes that we were talking about earlier with Cristoph around responsibility and some of the more conceptual aspects of all of this. And I want to ask you this question, Cristoph. So when an autonomous crypto agent does something harmful, so let's say it executes a trade that crashes a system, can we say that anyone has done something wrong, or are there any sort of black holes in terms of accountability in a scenario like that?
Well, of course there are huge black holes. I mean, I think the way I think about that when I came here, it kept bugging me. And we in the West are quite a weird kind of people, quite literally. That compared to other people, we place an enormous importance on choice and autonomy. So if you choose to put all your life savings in a casino, and if you freely choose to do that, it's all gone. And we said, it's fine, go, yeah, you chose. So, and if you were somehow coerced in a weird way then it would be not okay. So the edge, the cutting, where the law cuts through, is kind of this very delicate internal state of choice. Most societies don't view it that way. I mean, there's this great Harvard anthropologist, Joseph Henrich. You should all read the book, The Weirdest People, and weird stands for Western, educated, industrialized, rich, and democratic. And he gives you an outline of how weird we really are in the West. We think it's normal to do that, but most cultures throughout history and around the globe don't care about your internal state. It doesn't matter. We obsess about it. Now, there's a couple of things in the law that pushes against that. Of course, consumer protection law, jus cogens and other, where suddenly, choice doesn't matter. And we see that in crypto too. In crypto, strangely, in Bitcoin, for instance, in a blockchain, what matters isn't choice but control, which is a completely different concept. And you see that in the new development of private law in the United States, Article 12 Uniform Commercial Code, that what matters is not how you got control of your cryptos, but that you have control. It's the old possession element. So that pushes to some extent. I mean, our private law is very much, an attempt to make sense of this very delicate notion of choice, and in contract law and property law and everything, and how this choice can realize, and these huge monetary allocations that we then collectively allocate funds and opportunities and risks according to this very delicate internal happening of I want to, or I have been coerced, or have been tricked or manipulated or whatever. So now in crypto we already see that there is suddenly control that matters. Not in England, English law, but in the US law they go towards negotiability, towards taking free of any prior security interest, etc. If you have it, it's like cash. If you have it, it belongs to you. However you got it, So that's a significant shift, and I think it's a bit of a cope because there's no other way to deal with it. You could try to say, well, you have it, but somebody else owns it, but he can never get it, because you have it now. You can kind of force you maybe somehow, but that's a shift. And then with AI, there comes kind of a second layer of this unseating of the agency of the person and kind of an outsourcing of the agency. And I think, of course, if you have these two in one, that might produce, I think, quite a significant, deep kind of restructuring or paradigm shift of how we understand our interaction, and how we understand, notions of reliance and trust, and because trust is this moral relation as opposed to reliance. Reliance is kind of I rely on a bridge that it won't break down. I rely on it. I don't have any personal relationship with this bridge. But if I trust someone, this is a moral relationship. I mean, philosophically, we say that trust is a relationship where my trusting the other person gives the other person reason to do what I trust them to do. So kind of my vulnerability is supposed to motivate the other person to act in accordance. So it's nothing to do with reliance. It's a chance of the other person to show their moral worth. They don't have to give me back my money. They don't. It's an uncollateralized loan. That's a classic trust. I give them my money and say, I trust you give it back. And it's very difficult to conceptualize, or it's very difficult to automate. It's very easy to automate reliance. Yes, that's why it's very easy to automate collateralized loans. But in order to automate uncollateralized loans, you need to somehow make sense of with reputation systems or something like that, star systems like Uber. You have to somehow find a way to assess the goodness, the worth. Is this person worth my trust? It's value. In Latin, in German we say Bonität, which means goodness. A person is good, my trust. It's a good person, and it's the same as trustworthy in terms of monetary value. So I'm telling you that these legal arrangements and new technological challenges, they're not just surface ripples, but they cut rather deeply into our conception of what a human being is and how interaction works and how do we live well together. And they might, not unseat necessarily. I mean, the law will deal with that in the end, but they are not skin deep. They go rather deeply, and so the challenges that we have will take some time, and luckily the common law is quite good at that, to take its time, and the regulation usually doesn't get the complexity. It just regulates something like the MiCA, and nobody understands what it's regulating, but it's a different animal.
Yeah. Okay, so I think I've probably got an idea of what you'll say to the next question, which is to do with Law 1.0 against Law 2.0. And, you know, I mean, a lot of this discussion is all about how do we take existing and long-standing legal doctrines and apply them to these autonomous agents. And we've heard a little bit earlier this morning about regulation and the flaws and the challenges with regulation. But you know, do you think that we need completely new regulation for this world?
Yeah, I think we do need regulation, but we need good regulation, and good regulation understands the phenomenon is regulating not completely, but really on a technical and a technological level. And in America, it seems to me in the United States, they've taken some time, and in the UK, they've taken some time to understand and digest the technology, go through all the court cases, rather than regulate the thing they don't really understand. Usually we say, I mean, Law 1.0 is the classic, you know, private law, you know, the classic, you know, that's been here for ages. It represents, you know, something of a philosophic treatise of what a human being is, what its freedom is, what's important, what its value, how it interacts. It is usually a coherent narrative of how to live. Where does my freedom end and your freedom begin? That's what the French Code Civil, or in codified form, but you don't need that in a common law. It's an attempt to understand, you know, what it means to be human. And they have a coherent vision of how to live as a human being. Whereas regulation just solves certain issues. I think we need regulation, yep. But regulation has to be, I think, come at the very end, and after we've understood it. That's why I think the European way to do it is to regulate before it's understood. It's the worst thing you could do, yeah. Because it stops healthy, it supports, I think, regulatory arbitrage, rent seekers, and it stops proper genuine innovators. Because what you said before, you talked about the speed of innovation. I share with Mark Andreessen the view it's not about innovation. It's about commercialization. That's what's really making the difference. So there's a lot of ideas of what AI and crypto is going to do. The big thing is which is going to be commercially viable, which is going to really survive, because commercialization links the interests of the people with this innovation. There's a lot of ideas you could have that could happen. None of this is going to happen usually. Only the things that are commercially viable. That's why commercialization is so important, and bad regulation hinders commercialization, and commercialization is where the interest of the people and the innovation touch each other. So that's why it's so important.
And I want to bring Sam in on that, the concept of stifling innovation, and what your thoughts are on that, and I suppose the balance between, you know, keeping commercial interests safe and not stifling innovation as we develop these systems.
I think that's an interesting one, because as a research engineer and somebody working in innovation, I pay very little attention to regulations. And I never sit down to think, am I allowed to do this before I start doing something? It's more, I wonder how that works, or I wonder if this can do that. And I think, you know, Cristoph, your point there is absolutely bang on. It's when you look at the commercialization of that. And I was having a really interesting conversation with an entrepreneur that we're doing some work with around using AI agents and investment opportunities. And one of the comments I made to him when we were looking to spin this thing up is like, oh, I can introduce you to some of the guys that we've got at FTI who do work on compliance and regulation and can help you out with that bit. And he got quite annoyed at that, because he didn't want to have any of that. He wanted to go and build the thing, get it deployed, get it commercial, start driving revenue. And then his view is that, a bit like Facebook and Uber in some ways, you know, once you have these fundamental platforms which are doing something new, generating a lot of revenue, then you just let the regulators catch up. And I think that that's sort of, from an innovation aspect, the approach that we want to take. You know, we want to go and build these things. If we build something that is academically interesting and we get some papers out of it, fantastic. We do something which is commercially and we get all of that, and we, you know, generate a new company, we generate a completely new way of doing something, then we will worry about the regulators. You know, that can all be solved. Regulators, they can be rewritten, they can be changed. We can change the product. You know, Uber went from being a technology platform to a taxi company to not employing anybody to employing drivers, etc. Both sides can change to get what they want. So I think as we build these things out, we make sure we're not doing anything illegal or terrible, but we generally don't pay too much attention.
Okay. I want to talk, Christoph, one more topic, and then I just want to talk to Daniel about some of the sort of the litigation and court-related issues, which is on-chain jurisprudence. So if dispute resolution is built into code, so obviously, smart contracts deciding outcomes is the example. Are we creating a new form of private law, if that happens? And then what should national courts do? Should national courts respect that or seek to override it?
Great question, and it brings me back to this notion of Law 1.0, Law 2.0, and that's Law 3.0, and that's a kind of a nomenclature I've taken from Roger Brownsword, who's one of my colleagues at King's College London. He also used to be a philosopher, working on Kelsen and Hart and Raz, and then moved on to technology, so quite a similar trajectory. And he's coined these phases. So Law 1.1 is where the law, just private law, old applies. We've done that. We apply old law to new cases. We've done that. It's nothing special. Law 2.0 is where the regulator says, well, there's a specific phenomenon. Let us have specific rules for that. Now, Law 3.0 is the interesting thing. It's where you don't have law, but where the technology itself fulfills the purpose of the role. That Law 2.2, simple mechanism is the gates in, or example is the gates in airports. You could either have a rule that says you're not allowed to trespass, and if you trespass, you have to pay a fine, or you have these kind of gates where it just can't, it's just impossible to walk against. Or you have immobilizers in car. You can either tell people you're not allowed to drive under influence, and if you do, you're going to have these punishments that could be Law 0.10 or 2.0, or you just have an immobilizer. You just can't do it. And blockchain, of course, smart contracts is very much in this Law 3.0 field. Yeah. That just makes certain things important. It just creates facts. And there we have this tension between, the virtue of finality. Sometimes you just want a conclusion quick and fast. And it's better to have a fast and wrong conclusion than a, retarded, late, right one, So, because justice delayed, it's justice denied. So you have this balance between the two, but you have a lot of costs, because what you lose in these is that you have, I'm all for these innovations, but you lose out of sight maybe the one coherent image of what a human being is and what it means to be and how to live well, as a human being. You can try, of course you have always the human in the loop, but this is just a kind of a further expansion of legal regulation through technology. Sometimes it's called code as law or something like that. When smart contracts came up, it was a big debate about lawyers about how do we understand this thing? But there is a political issue about that, is that this happens completely detached from a lot of democratic control, which is fine. You don't have to engage with that. So I'm giving kind of a bit of an uninteresting answer of saying, well, you have to balance all these three and have to find a way to, but there are dangers and opportunities which we need to balance.
Daniel, I just wanted to get your thoughts on this topic as well. We did the case together with Kleros jurors. I don't know if people are familiar with Kleros, but it's a sort of completely online dispute resolution mechanism that's often baked into some of these cryptocurrency transactions. It was interesting talking to the judge about that. What's your thoughts at the moment on whether the English courts are willing to defer to these on-chain dispute resolution mechanisms, and then what's the tension in terms of them retaining jurisdiction?
No, I think in principle, yes, a judge would defer to a dispute resolution mechanism that the parties have chosen. It happens all the time. People choose arbitration, or they choose for an expert to determine their accounting dispute. Sometimes, I'd never understood this, sometimes they even choose barristers to adjudicate their disputes. But the case we had, they had chosen a decentralized dispute resolution mechanism where a community of jurors voted for who they thought should win the dispute. You submitted it, went off, these anonymous people sort of metaphorically pressing their keypads, and then you got a winner. I think all judges struggle with the idea that they should not be the judge to determine the dispute. There's sort of a natural human reaction to want to be the person who makes the decision. But if it's set up properly, I think that those sorts of provisions would be enforceable. The devil is in the detail. I mean, does an expert accountant who's asked to resolve an accountancy dispute between two joint venture partners as to their accounts have the ability to also determine contested issues of law as a part of that determination, or can they only do the accounting? And so you can imagine a million ways that creative lawyers can find to get the dispute back before a judge.
Okay. I want to just move on a little bit more to talk about liability, or come back to what we were talking about a bit earlier on about liability. So when things go wrong in these decentralized systems, and crypto transactions are the ones that we've worked on together, but actually more broadly, who realistically can be sued in these situations? Is it developers? Is it miners, validators, counterparties? How are the courts starting to draw the lines on who bears legal liability?
Well, I see liability everywhere. I mean, maybe it's a hazard of the job. If you think about an autonomous car, I mean, the person driving the car is an obvious target to be sued. The person who made the car. Now, when you think about blockchain technology, I mean, if you look at the white paper, the whole idea is to cut out the intermediary. You don't need the bank anymore. You have a decentralized network. And now suddenly there are other actors in the frame. There are the software developers who write the code that facilitate, the software protocols that facilitate these transactions. There are the miners, the validators on the chain. There may be a fraudster who's taken the assets. There may be a counterparty who's using the software. So these are all, to my mind, potential targets for litigation. And none of this is worked out because none of these disputes have ever gone far enough or with enough innovation for me to be able to say, yes, there's liability in that case, no, there's no liability in that case. But you might think it's a stretch that a software developer, I mean, these people who, actually doing the business end of developing the code, sitting in their basement in, I always pitch them in California, but they're all around the world, actually. Is the person liable when somebody steals or you mislay your Bitcoin or whatever token it is? You might think that's a stretch, but in England, it's at least sufficiently arguable that you will get, you'll be able to proceed with your claim, you'll get an injunctive relief, if necessary, against the software developer in certain circumstances. So other actors, I mean, you talk about DAO, let's say that, you've tried to give over control of your code to this decentralized body. Sue the DAO. I mean, these are real people, and I think a good test of who's worth suing is who's got the assets. I mean, not necessarily the assets that you can show passed from hand to hand, as it will, chain to chain, but who's got money. And that's really what I'm only interested in. It makes it sound very 2D, but I am only interested in who's got the assets, how can we get the assets back, what's the most effective way to secure, and looking at who's got the money is a very good acid test of who's worth suing.
Christoph, you want to
So just quickly about the developers, because that's, I mean, in the Tulip case and in other cases, of course, in the Samurai Wallet case and in America, in the Tornado Cash case, the developers, they went to prison. They've been, that's a big thing. And in bringing back regulation, the new Clarity Act has folded in I forgot the name of the act, in Article 102, I think, where they explicitly protect developers and say, in the United States, you cannot, as a developer, you cannot be held liable. Because it has passed the House, but not the Senate, but it's likely, I think, it's a good chance to pass. That would be a regulation that actively cuts off liability, and then it would be clear, at least the lawyers will find another way around, but the developers don't have the assets usually, so regulation does, in that sense, might do some good here,
yep.
in my sense.
And sometimes though, the developers are critical because they're the ones that can actually stop the button being pressed for the crypto to leave the wallet and essentially be taken by the fraudsters. And as you say, in some of the English cases recently, there is this suggestion, it's obiter, but that developers might owe fiduciary duties to participants in the relevant scheme, which is really interesting. I'm just conscious we've got 4 minutes left, and I just wanted to open the discussion to the floor if anybody's got any questions or comments for the panel.
So when I think about AI and crypto, so what I see is there are these AI and tech companies, and the entire the core of crypto was for decentralized finance, right? And now we have these tech companies, the power of which is with a selected few. And then comes the question of trust. And most of the people, I think, when it comes about trust, they look after state or like the lawmakers, right? And then I see there's this power struggle, that the three of them are trying to derive power from one another while still contesting for power. So where do you see the three? It's a triangular relationship for me. So where do you see how these three forces collide for power, and like how is the certainty going to be?
I couldn't hear the echo. I just couldn't hear the question. I'm very sorry. I'm an old man. I can't. Yeah.
Just repeat the last part of the question. The three.
So there are
three. That you were saying are competing
so I see
against
three. So the entire point about crypto is decentralized finance, right? It's a decentralized market and everything. And then there's tech and AI, which is the powers with a very selected few institutions, right? And then comes the question of state, because a lot of people look at like the lawmakers and the state when it comes to trust, and then the three of these parties are contesting for power while deriving power from each other. So how do you see the forces collide?
So, well, yes. So it's the balance of power between the state and basically between private companies on who has the final say in the development of these technologies. Sam, do you want to give a couple of thoughts on that?
If I understand the question correctly, because I think it was interesting you were talking around Tornado Cash, because as a developer, the developer community, we found that quite terrifying.
Yeah.
Because we just develop stuff, and it's fun. At the time, I was working on so Tornado Cash is a zero knowledge. It's a cryptographic way to transfer assets without anybody knowing what's going on. And I was working on a very similar platform. And we were using the same fundamental cryptographic approach that Tornado Cash was using. And as soon as kind of Tornado Cash unfolded, we stopped development pretty damn quick. At the time, I was working for a Big Four consultancy as well. So we had that sort of added layer of terror, really, about what could happen. And I think, going back to that absolutely stifled innovation and creativity. We stopped doing that. The state, for whatever reason, went after these developers for developing something which then somebody used for nefarious purposes. And so because of that, we stopped what we were doing. And yeah, to be fair, we probably wouldn't have created something amazing off the back of it, but that whole innovation effort wasn't there anymore.
Yep. Okay. I think I'm just conscious of the time and trying to keep everything to schedule, so I'm going to draw things to a close there. Thank you very much to the panelists for such a rich discussion. What we've heard today is that the intersection of crypto and AI is full of opportunity, but also riddled with paradoxes. So we have machines that transact without humans. We have systems that claim to be trustless, but require trust. And we've got legal frameworks that, frankly, are struggling to catch up with all of the technological developments. So whether through innovation, governance, or jurisprudence, the challenge, I think, for all of us is to ensure that all of these new technologies serve society, but without escaping responsibility, or without escaping accountability. And so the future of crypto and AI isn't really just about code. It's about law, regulation, trust, and ultimately it's about responsibility. Thank you very much for listening.